I'm going to talk with you today about mandatory employment arbitration, and in particular how the faculty and a number of our students are contributing to the debates surrounding the use of mandatory employment arbitration. Just to clarify, employment arbitration has to do with the use of arbitration to settle disputes over employment and workplace matters that arise in non-union settings. We're not talking about grievance arbitration that appears as a result of clauses in a collective bargaining agreement in unionized settings. The use of mandatory arbitration has been extremely controversial over the last several decades. We're leaders in the analysis of both the usage and the effects and even the wider debates about that procedure. Our Dean, Alex Colvin, is the country's leading analyst. Throughout his career, Alex has been analyzing how frequently that procedure has been adopted and the consequences of it, and comparing the consequences for employees of being forced into mandatory employment arbitration. And many of those procedures are mandatory. Mandatory in the sense that the company sets up the procedure, the employee is required to process a dispute, for example, charging race or sex discrimination, or a dispute charging that an employee has been unfairly dismissed, which might, in certain circumstances, proceed through court action. With the presence of a mandatory procedure, the employee has to process that complaint through that procedure created by the firm, and most importantly, the decision of the arbitrator is binding. Now, Alex's research done with a number of our graduate students, a lot of it done with our former graduate student Mark Goff, who's now at Penn State, looks at and compares how the outcomes of bringing a complaint through mandatory employment arbitration compare to complaints that are brought through the court system. And they argue that the evidence shows that employees fare much less favorably in employment arbitration, that the awards awarded, the judgments made by an arbitrator are much lower than the judgments employees receive for comparable cases if that case would proceed through a court of law. They also argue that the frequency through which employees are able to bring disputes through employment arbitration is not particularly favorable. Now, many others have disputed that claim, that set of arguments. Some argue that they're just not making apples to apples comparison. For example, research that I've done with David Sherwin raises the issue that with courts of law, the frequency of summary judgments, of cases just being thrown out rather than proceeding through a case that a judge or a jury might hear, the frequency of such summary judgments is much higher than an equivalent action that might occur in employment arbitration, where arbitrators tend to be more favorably inclined to letting the individual sort of have their hearing, their day in court before the arbitrator at least, rather than make a summary judgment and throw out the case. Nonetheless, there's enormous dispute and debate. Alex, for example, argues that if we were going to change and improve our procedures, not only should we outlaw mandatory arbitration. Note that the federal government has recently banned the use of mandatory arbitration for cases involving sexual harassment. Nonetheless, many disputes don't involve sexual harassment and continue to proceed through these procedures. Anyway, Alex would argue both that we should not allow mandatory arbitration, but as well to improve access to judgment by individuals. Alex has argued that it would be helpful if the U.S., although he doesn't think this is likely in the near term, he thinks it would be helpful if we adopted a labor court type system of the sort that appears in other countries. I and many others are more favorably inclined towards employment arbitration. I oppose mandatory arbitration. I don't think that's fair. I actually don't understand why firms who are trying to become an employer of choice would force employees to proceed through that kind of structure. Dave Sherwin and I have been impressed by conversations we've had with a number of major hospitality firms who now provide employees with a choice. They're not forced into employment arbitration. They're offered to work under a just cause clause to replace employment at will in exchange for proceeding through employment arbitration. In addition, if one favors employment arbitration, you have to wrestle with the question of how can it be made fair? What kinds of due process requirements would you allow? Potentially having joint selection of the arbitrator by the employee and the firm, not have the arbitrator solely selected by the firm. And there's other issues surrounding how employment arbitration could be made fair. I like employment arbitration in part based on the experience I had as an administrator here at Cornell, where I saw that it was really healthy for disputes to be settled quickly and near the source. And I worry that waiting for a court of any sort to settle disputes, we know from the evidence that that takes an enormous amount of time and substantial resources. I like employment arbitration as long as it would be regulated through good due process procedures, because I think it has the potential to provide both quick and fair decisions. Nonetheless, whatever one thinks about these debates, the Scheinman Institute and its faculty and students are at the cutting edge of research, trying to explore what are the effects of employment arbitration, how could it be improved, and what are the alternatives to employment arbitration if we would go that route. Thanks a lot and take care.